Good afternoon, everybody. My name is Mark Huxley, and I've got the honour of navigating you through the latest Knowledge Miles 695th Lord Mayor's lecture. On this occasion, we're going to be looking at London dispute resolution, new goals for the leading city. So a quick rundown how the session's going to run. I'll properly introduce our lecturer speaker, Sir Gary Hickinbottom, in a moment, and he's going to speak to us for about 20 minutes. That will give us lots of time for questions, so please keep them coming in. Just to navigate you to the right part of the screen, top right-hand side on your screen, you'll see a little call-out chat box with a question mark in it. Please put your questions in there. Don't put them in the main chat, and please don't put your hand up because we just won't see them. So please use the specialist question area. We'll get through as many as we can. Often on these, we overrun with questions and time available, but all of the questions will be sent on to Gary afterwards. So, you know, if he so wishes, he can engage with you, and your details will be sent to him as well. So, and as I'm sure you're aware, the session is being recorded. There is a dedicated YouTube channel for all of the Knowledge Miles lectures. So you can go back, rewatch this one and any others that are in the program. So, So welcome, Gary, and thank you for joining us. A quick run through of Gary's long bio. So the Right Honourable Sir Gary Hickinbottom was a city solicitor for over 20 years before he became a full-time judge. During his 20 years as judge, he sat in a wide variety of roles, be it tribunals and courts, from a London parking adjudicator to a judge of the Court of Appeal. In 2021, subsequently retired from the Court of Appeal to conduct a commission of inquiry into governance and corruption in the British Virgin Islands, and now moving on to now, I'm guessing, I don't know whether that's still going on or not, Gary, but now is also the president of Welsh Tribunals, recently been appointed to chair the Post Office Overturned Convictions Independent Pecuniary Assessment Panel, chair of the Judicial Panel of the Lawn Tennis Association and of British Wrestling, and is a member of several other sports arbitration panels and appeal boards, spending a good deal of his time involved in sports dispute resolution as well as commercial arbitration. Is a registered mediator, fellow of the Chartered Institute of Arbitrators, who I believe who's producing today's event for us, so thank you to them. Freeman of the City of London, past master of the Worshipful Company of Arbitrators, and as parish clerk of St Faith's under St Paul's, a member of the Worshipful Company of Parish Clerks. Oh, I'm tired just reading that, Gary, let alone you doing it. But enough from me. Over to you, sir.
Oh, thank you very much. Good afternoon, everyone. Dispute resolution has always been an integral part of London's commercial and financial fabric. If you trade in goods or you trade in money, then you need appropriate mechanisms for resolving disputes that arise, and mechanisms that people have confidence in. In this country, and particularly in London, we have specialised courts designed to determine such disputes. A list is on your screen now. I didn't go through them, but the Commercial Court, Technology and Construction Court, and so on. These courts have judges who are experienced and expert in their field, who manage cases in accordance with court rules that have been specially adapted to deal with commercial and financial cases. And these are dispute resolving facilities provided by the state. However, the City of London has for centuries supplemented the state system by adopting their own private procedures. These were developed by, for example, the City of London guilds, which controlled their particular trade. So, for example, the Worshipful Company of Bakers had their own court, held at Bakers Hall, at which those bakers who were found to have undersold in terms of weight or had sold musty bread would be sanctioned. Wage and rent disputes would be determined, as would be disputes between various sections of the trade. The baking trade, as all trades in London, was a closed shop and self-regulating through its guild. And in addition, the court would also deal with disputes between bakers or involving the baking trade. Wider disputes could be referred to other city institutions, such as the Mayor and Court of Aldermen in the city. So these institutions dealt with both the discipline of the members of trades and disputes about trades, each necessary to maintain the integrity of a particular trade. As commerce in London grew and outgrew the ability of the courts to deal with disputes as trading parties would wish, these private procedures and the institutions that applied them became more formalised. By agreement, parties could contract out of the state system, they could choose their judge and could choose the procedures to be adopted. And at a time in the 19th century when the courts were overwhelmed by work, they could ensure that their disputes were dealt with in accordance with their rules that they had agreed, and be dealt with quickly. And out of this arose commercial arbitration, and the institutions in London that administered it in a way that was attractive not only to domestic parties, but also parties from other countries, given the international nature of commerce. For example, the London International Court of Arbitration was established in 1892 to support commercial arbitrations in the form of rules, procedures, and administrative support in individual cases. And there were and are many others. Those of you who are fortunate enough to have heard Nick Vinall's lecture on commercial arbitration earlier in this series will remember that he set out the factors still favouring London as a centre, he said the centre for international commercial arbitration, despite competition from other jurisdictions. They're listed here, and I'll come back to them later on in this talk. And we need to protect that commercial arbitration work, which is such an important feature of the working life of the city. But protecting work that we have in London has never been and never will be enough. This is one of the central themes of Michael Manelli's year as Lord Mayor, the concept of the coffee shop of London evolving new business and new ways to do business. And dispute resolution is no different. Today I'd like to talk briefly about how we in London, on the foundations I've referred to, are developing new dispute resolution techniques and how we are expanding the scope of the field in which they are applied. Arbitration, which I've already mentioned, and court litigation have their differences, but arbitration is essentially a private court procedure in which each party sets out its case and evidence, and the arbitrators give a binding and enforceable judgment or determination. But in some circumstances, that procedure isn't considered the optimal way of dealing with disputes. And so other procedures have been developed. First, non-arbitral but binding decisions. Certainly in a domestic context, parties can agree a procedure which results in a binding decision, but which is not technically an arbitration. The courts here have worked out criteria by which an arbitration can be identified, whatever the procedure is in fact called, and whether it is or is not an arbitration covered by the Arbitration Acts here is sometimes important. For example, I've recently chaired an appeal within the procedure set up by British Gymnastics to deal with claims of abuse within a training context arising out of the inquiry chaired by Anna White, where the only issue in the appeal was whether the procedure was an arbitration or not, because if it were an arbitration, as found by the initial tribunal, then the Limitation Act would restrict the complaints to those which arose in the previous 6 years. We decided that the procedure was a binding, non-arbitral process. Next on the list, expert determination. Although we have judges and arbitrators experienced in a particular field, they determine a matter on the evidence before them and not on the basis of their own knowledge. In an expert determination, an independent technical expert is appointed by the parties to conduct their own investigation and reach a decision on the basis of their own expertise, knowledge, and experience, without reference back to the parties. It's a technique often used in technical disputes with a single issue, such as quality or valuation. The resulting determination might be binding, it might not be binding, depending on the agreement of the parties. Next, neutral fact-finding. An investigation or inquiry by an independent person is able to obtain evidence and draw conclusions as to what happened or may have happened, and, if it's asked to do so, make recommendations as to future steps or action. Mediation, or in some areas as it's called, conciliation, this is a procedure in which an independent third party or mediator, rather than determining what happened, where the rights lie and who is liable, all of that being a judge's role, assists the parties in finding a mutually acceptable resolution of the issues between them. This is usually done in a series of shuttle meetings with the parties, individually or together, all at the same venue and over a relatively short period of time, usually no more than one day. It has the advantage of being able to focus on matters which might not be relevant in legal determination of the issues, such as a continuing commercial relationship, and it might result in an agreement containing terms which a court could not order, such as a minimum level of future trading. Early neutral evaluation. I find this is often particularly effective in narrow commercial disputes. A senior lawyer, perhaps indeed a retired judge, is sent submissions and a basic bundle of evidence, and they give an opinion on the merits, which hopefully reduces the range of reasonable settlements and encourages the parties to settle. The opinion may be, for example, that one party is likely to win on issue A, the other party is likely to win on issue B, and the likely range of damages is somewhere between X million and Y million dollars. And these techniques do not have red line boundaries. They can be merged and molded to suit a particular case. Two examples. First, the British gymnastics scheme, to which I've already referred, that has one independent person who oversees both investigation and any proceedings that arise as a consequence. Second, various compensation and redress schemes have been set up by the Post Office and the Department of Business and Trade to deal with claims made by postmasters who have been convicted of fraud or suffered other adverse consequences as a result of the Horizon computer scandal. As Mark mentioned at the outset, I chair the Post Office Overturned Convictions Independent Pecuniary Loss Assessment Panel, which is just one of those schemes. Some of the details of the schemes are confidential to the parties, but they variously include provisions for, and I've listed them in this slide. For example, the Post Office or the department recompense legal representatives and expert accountants who are acting on behalf of the claimants with a provision for either fixed costs or alternatively a procedure for assessment of costs to be payable to the claimant's representatives in any event. Secondly, a claimant may be able to accept a fixed sum as an initial offer on the basis of proof that they satisfy really basic criteria for inclusion in the scheme. For example, in the scheme that I'm involved in, that they were convicted and had their convictions overturned by the court, the fixed sum in that scheme being £600,000. It then has a procedure for a claimant who doesn't wish to accept that fixed sum to submit a detailed claim, to which the Post Office formally responds within a fixed period, with a view to progressing to a negotiated settlement. There may be provision for a facilitator who gathers evidence and ensures that each party is in the best position to make informed decisions on settlement. If a compromise is not possible, then several of the schemes have a procedure for an independent person or panel to assess any heads of loss that are not agreed on the basis of principles generally more generous than the common law and on a non-binding basis. And that panel includes perhaps lawyers like me, but also expert accountants and expert businessmen. In some of the schemes, there is a review process that enables an independent person to review an assessment for obvious errors. The process is not binding. It is without prejudice, and so a claimant who does not wish to accept a panel assessment can go off to court and sue the post office, and the assessment process will not feature or be referred to in those proceedings. But although, of course, no process can be quick enough in the circumstances of that scandal, the processes that have evolved resolve more claims more speedily and more satisfactorily than the courts or some other formal process possibly could. You'll recall that the private courts of the London Guilds had the power to determine not only disputes involving the relevant trade, but also what we would call regulatory or disciplinary proceedings brought against members of that trade. And as my last topic, I'd just like to return to those for a moment. Trade and professional disciplinary procedures have generally taken a path from internal self-regulation to one in which decisions are taken by independent persons or panels. So in most trades and professions, the regulation of participants has moved from being dealt with by the secretary or the board of the governing body, for example, the guild, to being dealt with now through a process in which any ultimate decision of any seriousness is made by an independent person or panel acting in a judicial capacity. And that same journey has been taken by most national governing bodies of sports. And so, as Mark said at the beginning, I chair the judicial panel for the Lawn Tennis Association and British Wrestling, and I'm a member of a number of other sports panels which deal with regulatory issues such as discipline, safeguarding, anti-doping, licensing. And that trend is reflected more or less in international governing bodies too. These provisions are contractual, so each participant in the sport agrees to them or is deemed to have agreed to them as a condition of participating. And participant here is generally given a very broad meaning to cover anyone who has anything to do with the sport. Players, the parents of child players, coaches, officials, spectators, even the drivers of buses that take players to events. Everybody connected with the sport. And this new area of legal activity is one which London has seized. We have, of course, the advantages that London has as a commercial arbitration centre that were listed on one of the earlier slides. A stable law which is capable of adaptation, supportive courts, and importantly, professional talent in the form of lawyers experienced and expert in sports law, who act as advocates or often sole members or chairing panel members, and also those experienced in various relevant aspects of sport, for example, the technical, the commercial, and safeguarding. And we've also developed one of the world's leading sport dispute resolution service providers in Sport Resolutions, which has a home in St Paul's in the heart of the city. The need for such an institution became clear in the 1990s in the wake of the dispute between British Athletics and Diane Modal, which I'm sure many of you will recall. Modal was sent home from the 1994 Commonwealth Games in Canada and banned from all competitions following a positive drug test. Following lengthy disciplinary proceedings, which required several heavy visits to the courts, evidence emerged that the laboratory in Lisbon, which had stored her sample, had stored it under a window in heat of 35 degrees centigrade for 3 days, causing serious bacterial degradation. And on the basis of that evidence, all charges against her by all bodies were dismissed, and she returned to competing. But the proceedings resulted in the financial ruin of both Miss Madal and also of British athletics. There was already one institution, the Court of Arbitration in Sport, set up in Lausanne in 1983 by the International Olympic Committee to determine international sport disputes. But firstly, it was owned and funded by the IOC, and it was consequently politically driven, and it was not perceived as being as independent as it might be, with substantial input into its organisation and running from the IOC. Secondly, it only dealt with international disputes. And thirdly, it was very expensive to use. So a need was identified for a service to maintain the vital integrity of sport by supporting sport governing bodies with regulation and other forms of dispute resolution that would be independent, speedy, and cost-effective. Sport Resolutions was established in 1997 as a non-profit making organisation to perform that function, and with a business model that was aimed at ensuring its service was independent, speedy, and affordable. It started by focusing on regulation in elite sports, but it has expanded over time, particularly over the last decade, in terms of what it does and the sports and international federations with which it is involved. It now provides services to all sports, including those that are not well funded, and including, in terms of function, those that now appear on the screen, which cover all the dispute resolution techniques to which I've referred, and indeed more. For example, sports can go to Sport Resolutions to obtain advisory opinions from an independent lawyer on, for example, the meaning of a rule. It will conduct investigations and reviews. For example, the recent Welsh Rugby Union independent review into its failure to support rugby for women and girls, bullying and the use of sexist, homophobic and racist language. Sport Resolutions will make appointments to individual tribunal panels from its panel of over 350 lawyers and non-lawyers. It will and does conduct commercial arbitrations within sport, for example, between a player and a manager or a club. It manages whole panels. For example, it manages the National Safeguarding Panel and the National Anti-Doping Panel, as well as giving administrative support to individual cases. It runs a programme which receives and investigates any safeguarding complaints and concerns, managing each case through to a conclusion, which might, for example, be a reference to disciplinary proceedings. It runs Sport Integrity, which is a disclosure and reporting service for Olympic and Paralympic athletes. And just as important as everything else, it has a panel of lawyers willing to give pro bono advice to athletes, often at short notice, which it does in about 1/3 of the cases which are referred to it. In my view, this is a great success story which very much fits into the Lord Mayor's vision for London. A need was identified and filled, drawing on the advantages London has to offer, and this service offers pretty well anything which might assist in the regulation of sport and sport disputes. It is driven and tailored to need. It's been developed into one of the world's most respected sport regulation and dispute resolution support services, which in addition to national governing bodies now supports 26 international federations and 13 world, regional anti-doping associations. Some figures on what it does and how it's grown over the last few years are set out on this slide. It has therefore reached out and created not just a national, but a rapidly expanding international institution. It is with that success story, typical, I think, of London and built on the city's foundations, that I end this short talk, but I'm very happy to try and answer any questions that you have. Thank you, Mark.
Gary, thank you. Super interesting. And kind of good. We'll get straight into the questions. Good that you kind of centre on the international piece, because there's a question on there saying, are there any international centres that are competing in the same space as London in terms of arbitration and dispute resolution? You've made a great case for London, but it broadens out what makes London so appealing in this regard if one compares it internationally.
Yeah, two facets to that question, really. Firstly, as it were, all arbitrations, including commercial arbitrations, and those are the factors which Nick Vinell stressed in his talk. The English language is a big plus for commercial arbitration. The fact that we have a stable set of laws which are capable of evolving as commerce evolves, and really importantly, we have the facilities, including the professional facilities in terms of lawyers, that enable arbitrations to be conducted in London, often with London lawyers working with lawyers from other jurisdictions. In terms of sport, the two big players in the international field are CAS, Court of Arbitration in Sport in Lausanne, and now Sport Resolutions. With Sport Resolutions, as I've explained, taking more of the field as more international federations have confidence in it and use it for their work.
Right, okay. Audience, please do keep the questions coming in. There's a couple more in there. One is about more kind of pan-domicile situations now, where if you're in an online world and an event happens somewhere online, but it's being hosted elsewhere and the corporation might be in a third-party country, again, in that international context, are there any nuances and subtleties where you have to work internationally, or can that still just purely be run out of London?
Certainly quite a lot of the work that's done from London is done either entirely online or in a hybrid way. So I've conducted work from London where I've chaired a panel with a second panel member live in London, and we had lots of witnesses over several days in London. But the third member of the panel was in Seattle, and we had some witnesses in Dubai. So we dealt with the other panel member joined obviously online throughout his night every day of the hearing, and then we had the Dubai witnesses. Their evidence was taken online from Dubai in our afternoon. Hybrid working is very much the norm, and Sport Resolutions have facilities both for hearings and particularly for hybrid hearings. So as with most legal work now, distance is no object.
Okay, and I assume, sorry, a thought from me, I assume Brexit's played no material role in that in any way, shape or form of cross-border agreements?
Yeah, that's quite an interesting question. I wouldn't say it's played no part. I think the part that it has played, and it's one, for example, which I think Sport Resolutions has had to face, it is international federations which are focused on Europe have tended to be more sceptical of London since Brexit. And I think that's something we are overcoming, if we haven't already overcome it. But I think there was some work to do after Brexit to show that London was still the centre to come to for sport dispute resolution on a European and international stage.
Okay. There's quite a kind of binary question here. Does the Lord Mayor still have an active role in dispute resolution as part of his office?
That's a good question. I think that the Lord Mayor still sits as a magistrate in the City of London Court. I think he both has the right to and does sit in that capacity. But I think that's about it. I think.
Okay, that's very good. Another question up, we're slightly back on the international theme. Does Britain's common law system make it a more desirable destination for resolutions internationally?
I, in some ways, I think yes, because the common law has both certainty, but also, unlike the civil law, which is all written down, it has the ability to adapt to new situations. And in all sorts of dispute resolutions, in all sorts of walks of life, we are now moving so fast. Having an adaptable system of law, I think, helps. But both in international dispute resolution, whether it's commercial or sport, the procedures have been adapted to make them international. And so it doesn't matter whether parties come from the UK or abroad, the procedures will not be entirely alien to them. Some international federations, which are American dominated, tend to have really quite heavily common law procedures, for example, in terms of disclosure. But others have a more flexible procedures and ones which those from civil jurisdictions would be more comfortable with.
Okay. Question around, it seems very much in the way you framed the lecture that there's been an ever increasing kind of footprint, breadth, and capability of dispute resolution going on. So, is that constant? Will that continue? Are there gaps sitting in there? And will there be a tipping point where actually it really is seen as a true alternative to litigation? You know, we kind of kind of the way you were framing it still fits. Kind of litigation goes its route, ADR's going its route. Will the two really kind of bind together?
Again, that's a really interesting question. The court proceedings, although they have become more flexible over the last 10 or 20 years, are still quite inflexible in what they do. And court proceedings, on the basis of evidence, come to a determination. They determine what happened. They determine who is liable for it. Full stop. And I think in some fields, particularly I think commercial fields as opposed to regulatory fields, that's often quite a clumsy way of resolving disputes. And so quite a lot of work now goes into avoiding disputes altogether by, for example, in contract drafting, and where disputes arise, having more flexible dispute resolution procedures, which, as I said in my talk, enable things like continuing commercial relationships to be recognised and allows for an agreement which benefits both parties, but doesn't necessarily reflect the true legal rights and wrongs of the dispute. For example, in expressing a particular level of future trading in a continuing commercial relationship. I certainly think that all of these alternative dispute resolution techniques, which I've referred to, they will be added to, because I don't think there is any limit to the imagination of lawyers and others in coming up with more helpful ways to deal with disputes. And one thing is artificial intelligence. Lawyers tend to be really scared of artificial intelligence. Courts don't like it because there have been some well publicised instances of arguments in court which have been produced by artificial intelligence, and artificial intelligence has come up with some cases which don't exist, because guess what? Artificial intelligence is not intelligent. It is predictive, and therefore comes up with some odd results in some circumstances. So artificial intelligence really helpful in current dispute resolution, in straightforward things like translation, and in summarising in some circumstances, unhelpful in some parts. But I think it will have a part to play, because I think AI will have a part to play in every aspect of our lives. And I think that in some circumstances, particularly in low value disputes, low value bulk disputes, there is something to be said for an AI program which would come up with a result which would probably be right in most cases, and would probably be acceptable by both parties in most cases, but with a right to review by a real judge or a real arbitrator. And you'd have to choose the right area to deal to pilot this in. But I think there are certain areas of dispute where AI could be a real benefit in dispute resolution.
Mm. It's interesting. Just a slight kind of personal reflection on that. I come from the Lloyd's insurance market, so looking at AI and the role it's playing in there at the moment, there's now become a kind of recognised AI human intersection, and it's navigating around where that will be, where AI can do a lot of objective, heavy lifting data research for you, just to give you the tooling to be able to make the nuanced, qualified decision that you need to make at the end, and and certainly in my case, not relying on foggy old brains that kind of have forgotten more than it remembers, and is a life full of prejudice of things that you've seen and not. And I think that's interesting. I think to your point, with kind of dispute resolution being about the kind of the negotiated probability of success of a potential piece of litigation, that actually it can give you really good signposts, a bit of kind of decision tree navigation going through, and also about likely awards and that kind of stuff, because I guess it can get in a closed environment, can get into published legal records and precedent of what happened when, where. So I'm not sure there's a question there, but
No, but I think you're right, and I think it's a sort of early neutral evaluation, isn't it? It would be an artificial one, but it would produce an opinion based on prediction with the result of a case. The difficulty would be is to get a data set that would be big enough and reliable enough to give you a good prediction of result. So I think we start small in small cases in limited fields and see where that goes. But I think AI is something that we shouldn't be defensive about. It's something we should embrace, because it's going to come anyway, so we may as well use it. And I think it's got a huge potential for good, and if managed in the right way, of an overall benefit in dispute resolution as well as in other fields.
Okay. Got a final couple of threads of questions in there. Some about costs and the effectiveness of costs. Is ADR a good cost-efficient service? So there's some kind of commercial benefits from going into it. And with the various different platforms that you were talking about, is there a kind of disaggregation of those costs across the platforms, or is you're going to be in for a reasonably certain amount of money if you go down that route? Sorry, that was a very badly put question.
No. I mean, costs are always important, and they're as important in dispute resolution as anywhere else. Where the costs go differs depending on which technique you use. For example, the courts are relatively cheap. I mean, there are still court fees to pay, but the judge is free. Whereas if you go for arbitration, you have to pay possibly quite a lot on at commercial rates for for an arbitrator. On the other hand, arbitration is often much shorter because if the parties are both willing to crack on, you can agree a fairly short timetable, and in some courts it takes quite a long time to get a case on. The longer a case lasts, generally speaking, the more expensive it is. I'm not sure that many people would say that arbitration overall is cheaper than litigation, but it can be in appropriate cases if both parties are focused on cost effectiveness and the arbitrator has sufficient powers. Something like mediation, which is very short, a long mediation might last 1, possibly 2 days, whereas a court hearing or an arbitration might last several weeks. Early neutral evaluation, again, very short, normally done on paper. So you send in some papers, you get an advice back. Some techniques are cheaper than others, but of course some techniques such as mediation and early neutral evaluation do not necessarily end up with a result. You may have to slip back into arbitration or court proceedings to get a determination of the issues. In terms of different platforms, as I said in the talk, sport resolutions is non-profit making and is designed to be cost effective and affordable. And so it does things like, firstly, it doesn't pay its panel members commercial rates. It effectively pays them sort of judicial rates, which are a lot less. And it does that deliberately to keep the costs down. And on the basis that the integrity of sport, which it is about, is in part a matter of, as it were, public service, public interest. And it also is flexible so that the parties do not have to have 3 arbitrators, which you do with CAS. You can have a single arbitrator. You can have a single arbitrator doing an arbitration on the papers. So it's both cheaper on rates and also more flexible in reducing, for example, the cost of a panel.
Okay. Kind of a final question coming in. Apologies if it's telling you my front door is ringing, the vagaries of a ring doorbell. Sorry, final question sitting in there about choosing the right platform for dispute resolution. I mean, you put so many acronyms out there of different panels sit out there. How do you navigate your way into it?
Yeah, I think that's a very good question, and it bites at least 2 stages. Firstly, at the time of the contract, and as I say, even the regulation of sport is based on contract. The rules of the sport are a contract between participants and the governing body. Commercial disputes are obviously a matter of contract, and so what's put into the contract is important. And what's put into contracts varies very much. But normally what is put in is aimed to result at a final determination. It's not aimed at anything less than that. On the way there, it may have provisions for sort of mediation or other informal ways. But generally speaking, one would look at these techniques such as early neutral evaluation or mediation early on in a dispute to try and crack it, effectively to settle it with help at an early stage when costs are being saved and when perhaps a commercial relationship is being saved, rather than go to the end of the road, which may be a long and expensive one. So you've got to look at what you want and how much you want to spend on getting it.
Perfect. We are running onto time, so that's a perfect place to finish. I think there's a couple of call outs for some upcoming lectures. I think there should be a screen coming on, chaps. Coming behind there. Yeah, there we go. Yeah, well done, well done. So I should leave you to pick your way through those, although the word Footsteps of Shackleton must always stand out as something definitely worth tuning into. So really, it's just a series of thank yous. Gary, we established I come from the insurance industry. It has been a very mature beneficiary of ADR in commercially resolving unnecessary litigation and just letting people get on and get businesses back on doing what they're doing. So you'll always get a thumbs up from my industry for the great work you do. But thank you for sharing such interesting and insightful lecture with us. As always, thank you to the Lord Mayor, Michael Manelli, for putting this whole series on. I mean, I think it's going to get up to around 100 lectures by the end of it. It's been such a fascinating and interesting year of diversity. So thank you there. To his and our friends at ZN for producing the series, to help us sitting in the background today. So thank you for that. Obviously, massive thank you to the audience for tuning in, for all your questions. You'll be pleased to know we got through them all, Gary. So you've got no homework to do at the end of this. No bedtime reading sitting in there. So that's about it, really. So just to wrap up, big thank you once again, and just send you all very good wishes for the rest of your weeks. Thank you.